The next evidentiary motion is Mr. Williams has filed a motion. And again, I don't know whether this is styled for reconsideration or what, but it's an issue we're going to have to deal with going forward. So while I'm not reconsidering prior rulings, we do have to sort out how we're going to handle this moving forward. And that is concerning 801 and self-serving statements. So Mr. Steele.
There's been a lot of objections. Can't change the past. I've objected to it all. Over objection, I've been prevented from trying the case and putting on evidence based upon this so-called self-serving statement. My understanding, Your Honor, is that changed with the new evidence code. And I cited for the court in my motion that I filed on, Attorney Adams, and I filed on July 10, 2024. Some cases, and I might have attached the cases actually to the motion. I can't remember now. Walker, W-A-L-K-E-R versus State, 306 Georgia, at page 44.
Can you give me just
of course.
1 second? I'm
of
sorry.
course. Okay. No.
What's so important? We interrupting court business like
Walker
this.
is W-A-L-K-E-R versus State, and it's 306 Georgia 44, specifically footnote 3, 829 Southeast 2D 121 2019 case, where our highest court wrote that and I'm quoting now, the blanket policy against self-serving statements might not have survived the passage of the Georgia New Evidence Code. Then in Jones versus State, it's 303 Georgia, 496, it's in Division 4, 813 Southeast 2D 360 2018. That case is a pre-January 1, 2013 trial. So the self-serving statement objection was valid. So that's why I put that case in the motion. And then it's a good case of Hodges, which it's State actually versus Hodges, H-O-D-G-E-S, 291-413, footnote 6, 728 Southeast 2D 582 2012. Obviously, that's before January 1, 2013. But what happened was our Supreme Court said that the new evidence code has indoctrinated or codified, I guess, OCGA section 24-8-801C, and that the new evidence code would not retain the self-serving statement rule. And instead, the court looks at relevance 401, 402, and then obviously 403 is for everything. In federal courts, United States versus Jackson, J-C-K-S-O-N, 780F2D, 1305, it's 7th Circuit, 1986. For over 40 years, self-serving rule was not followed in federal courts. And here, what was happening is anything said by Mr. Williams that I tried to get in on cross-examination would be met with an objection that was sustained as self-serving statements. At times, the recused Judge Glanville would allow it in under the rule of completeness, so 106, and 822 or 24-1-106 and 24-1-822. There were times that he let in, but self-serving statements were excluded, even though they weren't going to innocence, which under the old rule, self-serving statement has to go to innocence. That's why it's self-serving. But anyway, I'm not saying that it's ever going to come up, but it happens so frequently. I just wanted to be courteous because that's the way it was going for several months in the court. So I just wanted to raise that to your attention. That's really what it is. In paragraph 11 of that motion, Your Honor, there was not as much, but under, I think it's 24-8-801. You got, I'm looking at my computer, 2B. I'm not sure that's right, but I think it's 2B. It deals with a statement that's adopted. So Judge Glanville would allow in, well, this was sent on social media and your client didn't respond. Oh no, that's not accurate. Or there was an alleged meeting and your client was there and he didn't deny it. Or somebody else had a lyric in a musical song and your client didn't come back with the next verse and say, oh no, that doesn't apply. And that's not an adoption has to be specifically intended to adopt by your silence. Like, so anyway, those are my issues.
Okay.
They came up a lot. I'm not, Your Honor, I am not saying that there'll be issues going forward, but it like permeated this trial.
Okay. I appreciate you bringing all of that to my attention. And I mean, this isn't really, I guess this is more bringing it to my attention than anything else. We're not talking about anything specifically right now. And obviously, as we're moving forward, we'll take up specifics of things as I'm going to say as we get to them, although if there's evidence that either side knows they're going to be intending to use that might have issues or objections, let's try to deal with that to the extent we can before we're in front of the jury. I think I said that already. But, you know, I looked at all your case law and I've looked at the statute and I don't know whether maybe some people were just using self-serving as sort of shorthand for something. I don't know, but I agree that there is not that's really no longer the issue. And if something is going to be excluded, it's not going to be on the basis that it's self-serving. It's going to be on the basis that it's hearsay and there's no recognized codified exception that has been met. So, I mean, that'll be my intention going forward is, you know, to look and see, is it hearsay? And then if it is, and obviously a prior statement of your client is probably going to be hearsay unless and until he testifies. So the question is going to be, does it come in under an exception? Is it a prior consistent or a prior inconsistent statement? And with regard to adoptive admissions as well, I agree. There has to be something to indicate, not just I heard it and I didn't say no. It has to be I heard it and I didn't in some way dispute it when the circumstances would expect me to dispute it. So yeah, generally speaking, that's my understanding. And like I say, we'll take up the specifics as they come at us.
Thank you, Your Honor.
All right.
That was the totality of that.
Great. Thank you.
This is left. Can I ask a question?
Yes.
There's a, I don't know, I don't want to take something, but there's a transcript of the January 10th, 2024. That's yours?
Yes.
Okay, I just want to make sure.
I don't know. I think I handed yours back to you before.
Okay.
So I handed, or through my staff attorney, handed you back your copy. I don't know what that is. Okay, understood. All right. The state has a motion to exclude victim character evidence. It was filed on July 23rd, and I don't know if that's something that has been ruled on previously or what this one is really. Has that already been dealt with, or where are we on that?
It has come up, Your Honor, ADA action on behalf of the state. The state wanted to file that for the court's guidance of any motions where we were going through specifically Mr. Copeland's redactions.
Okay,
And there was a couple times, and Judge Glanville overruled the state's objection. We wanted some what we classified as speculative homicides that the deceased victim, Mr. Thomas, was involved in, that Mr. Copeland speaks about in his interviews.
okay,
And so those redaction conversations with the court were after June 12th. So the state, foreseeing and forecasting at least that specific issue and or additional questions that may come up, wanted to file this motion precluding improper victim character
okay.
evidence, Your Honor.
And flesh it out a little bit more for me.
Yes, Your Honor.
So Mr. Copeland wanted to testify to, and or you all had prior statements where he had mentioned and you wanted to get in him saying something about homicides that Mr. Thomas had been involved in perpetrating
So, Your Honor,
potentially?
yes, Your Honor. And I have some, let me draft these notes right here.
Okay,
Oh, no. I wanted to show these examples that I had. So, Your Honor,
uh-huh.
I printed some examples where Mr.
Okay.
Copeland, this was what the state wanted to keep out. So,
Wanted to keep out.
yes, Your Honor.
Okay.
And the way that the Honorable Chief Judge Glanville addressed these redactions was, state, let me know what you're not playing. And
Right.
then defense counsel would bring up questions they were going to ask Mr.
Okay.
Copeland and or play. So there was portions the state was not going to play and defense counsel said they wanted to get into, where
Okay.
Mr. Copeland is mentioning there's a murder on Auburn Avenue. There's an individual by the name of Scooter. And it comes up kind of off the cuff of he heard that Nutt had something to do with this murder. And so the state felt that that falls under what's kind of classically a specific bad act of a victim, which can't come in under really any witness to include a deceased victim in a case. And the case law and the state's motion on that is, explains all of that, I feel like, succinctly. And so the state, knowing that we're going to have to go back over these interviews with Mr. Copeland,
Okay,
and some of this may depend on the questions asked and his responses, the state filed this motion. There may be other instances. Those are what came to mind because we recently addressed those. And they're in a recorded statement of Mr. Copeland that the state did not want to play, but defense counsel wanted to ask Mr. Copeland about and or play it if it was impeachment.
under what basis, if y'all had gotten that far, and maybe it's more fair to ask the defense.
I was
under
gonna
what
say that, Your
basis,
Honor.
But,
I will defer to the defense on their basis for that because I don't want to misspeak
Okay.
for them.
all right. Somebody from the defense want to let me know what they might intend to argue with regard to this type of evidence?
Couple things. First of all, regarding Mr. Thomas's character in general, the state, and I defer to the recordings. I don't have it in front of me. I'm not intentionally misspeaking. My recollection is Miss Love indicated on January 10, 2015, Mr. Thomas was just hanging out, on the street with his good friends, having a good time and, just having a friendly time. And then these mean guys did this thing to him, which was misleading. But then the state presented witnesses that said that Mr. Thomas was a gang member. This wasn't us. We didn't bring this up, that he is a gang member, that he was a gang leader. And then they brought in experts that talked about If Gang, Inglewood Family Gang, and Bird Gang. And these are the gangs that Mr. Thomas was associated with. And so all this character evidence has really come from the state's witnesses, and it's been elicited by the state. Now, regarding what Mr. Atkins just spoke of, I think we're putting the cart a little bit before the horse, because these are things that Mr. Copeland said in out-of-court statements.
Mm-hmm.
I am not conceding. I hope Your Honor is considering the prior argument today about whether the statements regarding what Mr. Garlington said Mr. Garlington's statements, alleged statements to Mr. Copeland are even admissible. But then there's another issue. Even if they were admissible, our stance is that Mr. Copeland on the stand, and assuming he testifies consistent again, would not deny making those statements. So I don't even know why we're playing prior statements to begin with. All that being said, my recollection of the arguments were that Mr. Copeland was making references to what he knew about Mr. Thomas as, you know, a gang leader that may have been involved in other violent acts. My recollection of the litigation of that issue was that certain defendants, and it wasn't on behalf of Mr. Stillwell, but certain defendants have argued that Mr. Copeland is responsible for the death of Mr. Thomas. And the argument, as I recall it, was that if that's the defense's theory, that Mr. Copeland's belief and understanding, you got to remember in context, Mr. Copeland, aside from all the gentlemen here, was embroiled in his side controversy with Mr. Thomas's brother, Mr. Watts, Kelvin Watts. And there was a fight a couple days beforehand at Club Crucial where Mr. Copeland's face was blooded and he was robbed, essentially.
Right.
So he had this side disagreement going on with these individuals. And my recollection of the argument was that Mr. Copeland's knowledge and belief that Mr. Thomas had a history of violence created the motive to essentially a preemptive strike. That he knew that he was in a beef, in a disagreement with dangerous people, and that goes to his motive.
Okay, he's
Mr.
not,
Copeland.
yeah, who is not alleged to have had by anybody, as far as I can tell from what y'all have said to me today, to have had involvement in Mr. Thomas's murder before the fact.
I don't know. That's not been the state's theory, and that
Okay.
has not been Mr. Stillwell's
Okay.
theory. But that did come up.
Okay, well, it may be that what Mr. Copeland thinks about Mr. Thomas's violent reputation is entirely irrelevant then.
It may be irrelevant.
Okay.
I don't want to speak for other counsel, but that's my recollection
all right.
of the events. But again, I think that, in my personal opinion, the most prudent thing is to figure out which of these statements are
Right.
even going to be admissible
Sure.
first.
Yeah.
But in general, Your Honor, the defense is not, we haven't been bringing out evidence about Mr. Thomas. The state played a video where Mr. Thomas's brother was carrying an assault weapon in a barber shop at the time of the shooting. The state's witness said that Mr. Thomas.
Okay.
Your Honor,
Yes.
I wanted to briefly, if the court would permit, I found my notes just to
Okay.
give the court some examples.
Sure.
So these are from my notes, so the time hack should be pretty close. But for example, in the January 28, 2015 interview of Mr. Copeland at Atlanta Police Department headquarters, right around 7:48:13, which is the time that evidence reviewer uses, Detective Dennis asked, "What do you know about Nutt having anyone else out there?" I might have missed a word, either killed. There was some alluding to that. And Copeland, says, "On Cleveland, don't know much about it. What about the boy on Auburn?" And Copeland says, "Who? Scooter?" And Detective Gaither, another APD gang detective, says, "Mr. Copeland, tell us more." You start smiling. And Copeland says, "I heard something, but was not much. It's just like he did get caught up. Somebody had him killed." So it's that kind of, in the state's opinion, speculative examples of specific conduct. And that's why in the state's brief that I know the court has reviewed these briefings, a April 2024 Supreme Court of Georgia case, Ward v. State, 318 GA 884. I used in Ward, it's dealing with kind of the outer limits when someone's claiming self-defense. I like reading Ward, one, because it's the highest court in Georgia and it's recent, but number two, not being able to use specific acts of the victim as character evidence, and even a self-defense allegation, which no defendant in this case has alleged that they shot Mr. Thomas in self-defense, it still establishes it must be through reputation and opinion only. And so the state's it's a two-part motion specifically. Character of the victim is rarely relevant in a murder trial. And two, if it is relevant, it has to be through reputation or opinion on some salient issue. And three, what Mr. Copeland's discussing about, to the state's understanding, is quite speculative even at that. But the state's position is specific bad acts, which murder, I can't think of a more concrete example of a specific bad act of a witness or a deceased victim than murder. So speculating about that, the state feels that's just classic improper under 24-4-404 and 24-4-405 alpha.
Okay, well, I plan to follow 24-4, 404, and 405. That's about as much as I can say about that right now until we get into specifics either. All right. But thank you for at least fleshing it out so I understand what we're talking about. All right, the state has a motion to compel defendants' compliance with the reciprocal discovery obligations and to exclude evidence intentionally withheld and not timely disclosed. And I had via email asked specifically as to the authorship of this particular motion and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, I will be present. Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell. And then the statement, quote, a defendant has a duty, underlined, to disclose prior to trial and an ongoing duty to timely disclose, in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id, meaning see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
I didn't say solely as impeachment. I said as both impeachment and as substantive evidence.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying.
Well, you wrote it inartfully.
I did then, because what I was saying was that it has to be both. That is the representation that
all right.
I made. And then when I amended it.
I didn't see an amendment.
I have a copy for the court.
Did you fix that?
What I did was
thank you.
Sort of elaborate on it, or yes, I guess you could say it was fixed.
So you concede then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's
okay.
Yes, I was not saying that. I was saying
good to know.
My apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor, was.
Did you email the amendment to my chambers?
I did.
Okay.
Yesterday.
Yesterday. Okay.
Yes,
well, that may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop. Okay. It's in front of me now. So.
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716-4C1 requires. Then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343 and go on to say Georgia's discovery law does not explicitly apply 1716-4C to evidence used simply for the purpose of impeachment.
Okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite to relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control. Possession, custody, or control, my apologies. Where the defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
All right. So it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
That is, yes.
Okay. So as long as we're all on the same page with that, and I actually do think that to the extent anybody might want to take a closer look at what those distinctions are, I think it's Waddell,
Yes.
where the court actually says, hey, you know what, these can be tricky, these can be dicey. Here's what it means. Here's the difference between the two. So I would recommend for everybody's reading pleasure the court's exposition of that issue in the Waddell case.
And in that amendment, I did correct
All
the
right.
Waddell site.
Okay. All right. So we'll follow that law as well.
So, Your Honor,
So, yeah. And so I guess I don't know if you've got specifics with regard to things that you believe have not been turned over or
I
that
do.
exist and haven't been turned over.
Well,
Okay.
I cite, for example, in these amendment to the supplement on page 1, the first example was recordings that were held by counsel for defendant Williams of an interview conducted with state's witness Adrian Bean. The evidence that was shown at trial was that Mr. Bean was a co-conspirator with defendant Williams in an intrinsic armed robbery. The state conducted days worth of direct examination of Mr. Bean, only to learn the weekend before the day cross-examination of Mr. Bean was to begin that counsel for defendant Williams had a recording of an interview he had conducted along with his investigator, which had been in counsel's possession since January of 2023.
Okay.
In which Bean claimed that defendant Williams was never involved in the armed robbery, and in which Bean claimed that the police told him to put defendant Williams in the crime. Mr. Williams presented this statement not just as impeachment evidence, but as substantive evidence, and further based upon information provided by Bean to the state upon information and belief. The recording that was given to the state was only a portion of the recorded statement at issue. And we do not have, if there are further statements, if there are further recordings, we don't have them. We've not been offered them. We don't know what they consisted of. Another example is defendant Williams has asserted verbally that he is in possession of a video recorded statement of the witness currently on the stand in which that witness reportedly asserts, "We killed Nut," referring to Mr. Donovan Thomas. The state is not in possession of any such recording, is unaware of the existence of one, but as I stated earlier, Mr. Williams has asserted verbally that he has such a statement. Mr. Copeland, as I stated, is currently on the stand, and the state has not been given any such recording or been privy to or been able to review any such recording despite a specific and direct request for it. We assume that Defendant Williams intends to use the recording, if one even exists, not simply for impeachment purposes, but as substantive evidence. Given these explicit and deliberate decisions to withhold material specifically that we've outlined above, and I will also point the court's attention to a similar example of with intentionally holding back material. There were jail recordings of the witness on the stand now, Mr. Copeland, that apparently Defendant Williams has had in his possession for quite some time, long before Mr. Copeland took the stand. And we were only around the time that Mr. Copeland took the stand presented with these recordings. We expressed having a problem with being able to access them, and we were given another set of recordings that contained some other files that maybe were missing in the first one. But the withholding, the deliberate withholding of these items is what has prompted the state to ask the court for relief here. We are not asking the court to exclude late, disclosed discovery. That's not what we're asking for, but deliberate intentions to withhold information that a defendant intends to use both as substantive and impeachment at the same time. Evidence. We're asking for the relief that we have referenced in our initial motion. And if the court is not inclined, as we've stated on page 5 of our amendment and supplement to the state's motion to compel, we recognize that both Georgia and federal authority instruct that courts employ the least extreme sanction to remedy discovery violations. If the court deems exclusion of a particular piece of evidence too extreme, the state requests that the court issue an order directing defendants to permit the state to inspect and copy any and all material that a defendant possesses, which the defendant intends to admit as substantive evidence, even if the material is also impeaching of a witness, and directing that where the proffering defendant intentionally withholds such material, that it be admitted, if at all, solely as impeachment evidence, and with a limiting instruction prohibiting the jury from considering it as substantive evidence.
All right. So with regard to the 3 things that you outlined specifically, you now have the recordings of witness being, is that true?
We have one recording of witness Adrian Bean that apparently was made on an iPhone, but is, according to the information that the state received from the witness as he got off the stand, that may not reflect all of what was taken down.
What do you mean by taken down?
Well, there were, as the witness left the stand, he indicated that, and actually on the stand, he instructed Mr. Steele to keep it 100, implying that that's not everything. In other words, that what we were hearing was not everything. The recording itself was kind of degraded, and we were not, it did not appear to be one pulled directly off an iPhone the way that an iPhone would, the quality of an iPhone recording would be. And I apologize to the court, but there was one more instance. D'Angelo White was a witness that the state put on the stand, who represented to the state that that counsel for defendant Williams recorded the interview or appeared to be recording the interview that he conducted with D'Angelo White at the Fulton County Jail. We've never received any recording of an interview between counsel for defendant Williams or anybody else conducted at the Fulton County Jail. I believe I heard earlier reference today to, I don't know if I heard that was the subject of any ex parte hearings or meetings with the court between counsel for multiple defendants and the court. But if there were or are any interviews of D'Angelo White in anyone's possession or that were made, we would believe the state to be entitled to them. He was a witness who was examined and cross-examined on the stand. So there were 4 instances.
All right, well, he already has been examined and cross-examined?
Yes,
Okay, and no such recording was used?
right. They didn't.
Okay, then why would y'all be entitled to it?
It's just an example of something that we wouldn't, that we weren't aware of.
Okay, but y'all aren't entitled to be aware of every aspect of a defendant's
I don't
case.
disagree.
You are entitled to something that would have been a recording that then gets used as substantive evidence, but it sounds like that did not,
The court is
right?
correct.
Okay, so that one doesn't
scratch it
matter.
off.
Okay. So Mr. Williams saying he has a video recorded statement of Mr. Copeland saying we killed Nutt, which he might want to use as substantive evidence, as well as any jail recordings of jail calls of Kenneth Copeland, I guess, with anybody, I would assume.
And we have been,
Y'all got all of those too, right?
so we have been provided, these were not jail call recordings from the Fulton County Jail. They were
Okay.
from a different, but we've been provided according to defendant Williams, counsel for defendant Williams, we've been provided all that they have.
Okay.
And so if that is the case, then there is no further issue.
Okay, that one's fine too.
Correct.
So, Mr. Steele and or any other defense attorney, if you have recordings or statements or anything like that, that you intend to use as substantive evidence, whether it is in a case you might present later or the state's case, I think you know this, but need to disclose that to the state. Now, if it just comes up at the very end that, oh my gosh, I didn't know I was going to use this, but now I think I want to, then we might have to sort out whether that's in fact what's going on or not. But I expect everybody to abide by their discovery obligations. If I end up making a determination that somebody is willfully failing to abide by those obligations, then I will consider sanctions. But I would hope at this point, and with what I've already heard, I haven't really heard anything that I find alarming and improper. So unless anybody wants to say anything else, I'm just at this point going to say I expect y'all to abide by your discovery obligations.
And Your Honor, if I may add one more thing, I believe that counsel for defendant Williams emphatically stated he does intend to use a video recording that he has in his possession of the witness currently on the stand purportedly saying what he asserted, and that we're
Okay, well, I mean, I can see how that might be impeachment evidence, and I'll have to hear whether and how it might be substantive evidence. Mr. Steele.
May I have 1 second, Your Honor?
Sure. This is a long second, Mr. Steele.
No. Hopefully it'll be worth it. Your Honor, may I approach?
Yes. Thank you.
Thank you, Your Honor. So I believe that what the state has asked you to do and what you said from the bench about the law.
This as well, and I've
Okay.
been referencing the recorded proceedings to ensure that we are accurately keeping note of what has been and hasn't been
All right.
admitted. As I stated earlier, there have been instances where it has been proper that evidence has been admitted, it has been tendered.
Right.
That has not been the case. So we are still, and we would ask that the court allow us to get a little bit further along in checking all of these exhibits.
All right. So,
What has really and truly been admitted.
So the question was, do y'all have the kind of response from Ms. Weaver about her take on a couple of discrepancies? Okay. Ms. Percefield, could you share that with everybody? And I was hoping that we could do this today. If the state is not ready to yet, you know, I want to try to take us to the end of the day because we have a lot of work to do. Maybe there's something else that we still need to cover that we could cover today.
Judge, we are going through each piece of evidence, and we are comparing our record
Okay.
with the actual physical piece of evidence that we have submitted or the defendant has submitted. So that endeavor is
I'm sure it's time consuming, voluminous.
and we have endeavored to make certain that it's accurate. So
Well, that'll be helpful. We would want that. All right. So, Ms. Percefield will email out to y'all all the couple of comments that Ms. Weaver, in her looking back, believes might be inaccurate on the chart that Mr. Steele has put together and shared with everybody. So y'all can take a look at that. We can deal with it tomorrow. I know one thing that we're going to need to sort out. Ms. Weaver had mentioned that there are times when, and I think she said it was, I don't know who, but somebody on the defense side, or maybe more than one person on the defense side. I don't know if the state's doing it as well or not, but you will approach a witness with a laptop and show them something on the laptop and ask them about it. And that it is difficult for the court reporter to then sort out what was that exhibit actually. And I don't know if anything has been admitted that way, but I do know that the prior judge, there is an administrative order filed in April in this case that requires all evidence offered by any counsel be submitted to the court in physical form and marked as appropriate at the time of its admission for it to be properly made a part of the record, and directing counsel to provide physical copies to the official court reporter, who now obviously is no longer Ms. Weaver for going forward. It is going to be our new court reporter, Ms. Winfrey. But we actually need, you know, electronic copies too, but we need something that is physical, whether it's on a jump drive or a flash drive, or whether it's a piece of paper. There's no way for the court reporter to capture sort of, I guess, a screenshot, unless y'all take a screenshot of the screen that you're showing the witness and then give that piece of paper or electronic file to the court reporter. That would be fine, but there has to be something that represents whatever you showed the witness on the screen. Okay, does everybody understand? Anybody have any questions about that? Okay. So we can take up tomorrow, after y'all have had a chance to look at it, the couple of issues that Miss Weaver's got a different record than what Mr. Steele does. And then I would love for y'all to be able to get together on, if there's no discrepancy, then we don't have to worry about it if everybody's on the same page. But you know, if there is a discrepancy, if y'all don't talk to each other, maybe you could just email each other. Here's where we think there might be a question or an issue, so that we all know before we talk about it what it is that we need to talk about. So can y'all do that this evening? Don't ever, thank you. Okay. All right, very good. All right, the state has provided an updated witness list, which is still fairly long. And I would like to know from the state, does that list include, is that just the witnesses that have been called yet that still need to be called? Or does that include everybody, the witnesses who have been called and those who are still to be called?
Your Honor, that includes the witnesses that need to be called. Some have already been called, but
Yeah.
those are everyone moving
Yeah, there
forward.
were a few you highlighted and said we may recall these. So that is 105 or so witnesses still to go. Then.
Yes.
Okay. And is that with y'all narrowing it down and picking only the witnesses y'all need?
Yes.
Okay. Well, we'll see. But all right, are there any other, we've got to figure out how we're going to deal with Mr. Copeland's sort of redo. But are there any other motions that I haven't gotten to yet today or mentioned today that are outstanding?
I emailed Your Honor's chambers regarding motions that I filed, and because I did not have access to Odyssey and I could not pull them off the internet, and I did not have the file copies on my computer, I identified what they were, but they were noted. Essentially, I would think they're titled notices of objection. They were regarding. Your Honor may or may not know this. There was a wiretap in this case. There's then also my client's phone, actually 2 phones, were extracted and dumped. So there's numerous phone calls, texts, emails, things of that nature that are on either the wiretap that were intercepted, some involving some with my client as a party to those communications, some not, as well as all the things that are typically on a cell phone that deal with someone's essential life on an electronic device. The state has, to my knowledge, not identified what they plan to use from either of those sources of information at this time. And that's why I labeled it a notice, because there is irrelevant information, there is prejudicial information, there's on the wiretap, not so much Mr. Stillwell, but there's other individuals on these wiretaps discussing all sorts of other acts that have nothing to do with this case. And so there's just a lot there, and we're going to need to have that discussion at some time.
Okay, thank you. When does the state intend to let the defense know what it is they're actually using out of the universe of all possible things?
Your Honor, what I think that we have represented to the court previously is that prior to, I believe we had said at least the week before, because there is a large volume, to say the least, of calls within the jail calls and within the wiretap that are that have been turned over and discovered. And I believe that we had previously said that did we say the week before? 2 weeks before we intend to use them, we would apprise defendants of which ones.
Can y'all explain to me how you are dealing with a large volume of what ought to be motions in limine while in the midst of trial? And still being in any way efficient with the jury's time? You're not, essentially. Okay. All right. That's just not practical. I mean, we're going to change that going forward. And I'm not going to say I need you to know everything tomorrow, because I know it's a voluminous case, but y'all been putting this case together for 2 years. And you ought to know, I mean, you clearly know what witnesses you're going to be using, and you've given me, kind of a very broad idea of what exhibits you intend to use with those witnesses. But I don't know that if we're just every other week saying, okay, let's figure out all of the evidentiary issues that have to do with the next 2 weeks worth of witnesses. We can do that in one day on a Friday. We just can't. So we're not going to be able, I mean, we all know that we've got this week, and we know that the jury has already been told before I became involved that they essentially have the week of, what is it, August 19th out. So, this week might be taken up pretty much with sorting out the two things I just mentioned, and then sorting out all of the evidence that goes along with Mr. Copeland, because he's our next witness up. But the week of August 19th, we need to be plowing through a whole lot of other evidence, not just what's coming up in the next 2 weeks. We need to be covering the next several months, which ought to be, frankly, the end of this trial by then. I mean, it should not take another 7 months. It shouldn't. Whether it does or not, I don't know. But so the state needs to produce in much more detail a much more winnowed down but comprehensive list of what the evidence they intend to use with each witness is going to be, so that the defense can see it, evaluate it, make whatever evidentiary objections they have to it, and the court can have some time to view the evidence, listen to the evidence, whatever the evidence is, and evaluate the evidentiary issues, so that we know by the time the witness gets on the stand, here's what is coming in. I mean, for the most part, it's a trial, but what's coming in and what has already been excluded. So do I need to be more explicit about that? Or do y'all understand your marching orders?
Yes, we understand what the court is asking.
All right. So I feel like I need to be more explicit about it, even though I know y'all understand. By the beginning of next week, I want to see, at least the next 30 witnesses worth of evidence, okay? And then maybe by the end of that week, the next 30. Okay? All right, and we're going to plan to be here all of the 19th, and I don't know when else we're taking breaks, but okay, so that's that.
Can I ask a clarifying question, Your Honor?
Yes.
And Mr. Adams and I, Attorney Adams and I filed, I think that motion, it was not helpful just say like witness Kenneth Copeland, jail call, social media. I think you just covered that though.
Well, in fairness to the state, I do think that when I asked them for that, I said kind of broadly, let me know what evidence. And now I'm asking for it in more detail, just because practically speaking, in the middle of a trial, we've got to sort out what evidence is admissible, and ideally not while the jury's sitting there waiting on us.
That's perfect.
Okay.
We appreciate it. The specifics will make us roll better anyway.
Yeah.
Thank you.
All right. So any other motions that are still needing to be addressed? And y'all, it's 3:30 and I plan for us to do work until 5:30, and we can take a little break, but I'd really like for us to figure out something that we can make some progress on for the next 2 hours. So let's take a 10-minute break, be back, well, it's 3:34, be back at 3:45. And y'all think in the meantime, all right, what can we use this time productively to do? Thanks. back by the time I say be back, okay? Try to be back by the time that I say to be back.
Yes, Your Honor.
Thank you. There we go. Because I want to be efficient with y'all's time too. Okay, did anybody come up with anything else that we can be productive about today? All right, what is it?
I don't think my mic works that well, so I'm going to come up here. There are, way back when, and we're looking for the filing right now.
Okay,
There's back in, I would estimate, June of 2023, maybe. There was discussion that we needed to know all the alleged co-conspirator statements that the state intended to use, as well as any and all extrinsic acts that the state intended to introduce evidence of at trial. My recollection, and I would defer to that filing, was that there was only 3 801D2E
I don't know.
co-conspirator statements.
Okay,
There was only 3 listed, and then there was also a certain number of extrinsic acts
Okay.
that were listed. Throughout this trial, the state has gone past that list, and that has led to much delay and litigation and sending the jury out. So I think that's something we could discuss.
okay.
What if that is the entire list, which I submit it should be, we could discuss that. Also, there are, and I don't know if this falls under the discovery that we were going to talk about tomorrow, we are missing the reports of many experts
Okay,
that the state plans to call, is my understanding. Also, Your Honor, there are, in this case, the state, I believe, has announced that they plan to call 5 different gang experts.
and they've called 3 at this point, is that right?
I believe that is correct. I believe
Okay.
it's 3.
So maybe explore what, if anything, the other 2 are going to add?
And not only that, but the state has announced the intention to call a few of them multiple times.
Okay,
So that is another issue that's continuously come up in this case. Am I missing anything from our list? That was it? Okay.
okay.
So
all right.
those are the
Okay.
issues that we came up with.
Thank you. All right, and if the state needs the evening to, sort out everything and make sure that you're being inclusive and answering to the extent you know, that's fine. But if you know now, that's also fine. Do they have notice of all the different co-conspirator statements that the state intends to use and the extrinsic acts the state intends to use? Y'all can answer now, or y'all can say, give us till the morning.
Your Honor, I'd ask that the court just give me a moment. We're pulling up the.
Okay, all right. And while y'all are looking, I'm just going to make a general sort of admonition to not the parties and counsel, but anybody that wants to come in here to watch this case that, and I mentioned it before, but I don't know, I may have to mention it a couple of different times. I don't expect there to be frequent up and down, in and out. That's distracting. So try to keep that to a minimum. There shouldn't be any talking in court other than the parties maybe whispering between the attorneys and the clients in the court. If you're watching the case in here with us, and you need to say something to somebody else, step outside to do that. There doesn't need to be any it's just distracting. There's a lot going on and there's a lot to pay attention to. And when we've got other conversations going on, it's that much harder to focus on what we and I need to be focusing on. And I also want to make clear that the deputies in here have my full authority to manage this courtroom. So if they give you an instruction, you need to abide by it, okay? And I'm not talking about or to anybody specifically in here right now. Just some things I've noticed so far. And I, again, will probably make that announcement a couple of different times in the upcoming weeks so that everybody is clear on what the expectations are. Yeah. To whom should you what? Send it? Ms. Percival.
Your Honor, to the extent that the court's question was specifically, have we noticed the defense of the evidence of intrinsic acts? Is that the question that the
Well,
court asked?
no, maybe it wasn't very artfully formed, but to the extent you can, to the extent you know, and hopefully you know since you're in the middle of your case, I would like for you to make sure that you have given the defense notice of whatever co-conspirator statements you intend to use, and then separately, whatever extrinsic acts you intend to prove.
Okay.
And if you want to do that now, that's fine. Otherwise, that's something we can go over in detail tomorrow.
Judge, I'm looking at I'll start with just the intrinsic acts, and I'm looking at 51 of them. I'm not sure about the 3 that were referenced, but within the intrinsic act notice that we filed on November the 6th of 2023,
Okay.
we made specific references to 51. And we also said acts contained within this non-exhaustive list. We referenced that the list was non-exhaustive, and we noticed the defense of the state's intent to introduce evidence of these particular acts. If the court will permit me one moment, I just wanted to call the court's attention to the November 6th.
Okay, so given that you noticed 51 but said it was non-exhaustive, that sounds like there might be others. So at this point, can you make the list exhaustive?
Yes.
Okay. And then the 3 was co-conspirator statements. Well, we don't need to take court time now. How about you can you have tomorrow, by tomorrow, what all the co-conspirator statements are going to be? And then how much time do you need to make the other list exhaustive?
So Judge, what we're discussing is the number of co-conspirator statements that may be contained within the jail calls that we are also, jail calls and the wiretap calls that we are intending to introduce. And so to the extent that we reference simply what we filed, we can present that, but we would ask the court to allow us to address on the week that the jurors are out. The 19th?
So if it's anything with Mr. Copeland, that needs to get dealt with this week.
So with respect to Mr. Copeland.
Sure. Go ahead.
Okay, Your Honor. With respect to Kenneth Copeland, will the court permit the state to address in its entirety tomorrow the ones that we are intending to introduce? As we are discussing, those statements are contained within the videotape interviews and jail calls that we have intended to introduce and have noticed defense of our intent to introduce. So in terms of what the specific statements are, I think we would best be.
Okay, so does everybody from the defense understand, at least with regard to Mr. Copeland, maybe not in detail, but what the universe of potential statements is for Mr. Copeland? I mean, y'all had gone through a lot of this and hashed it out once already, and you might not have gotten through everything, but y'all had done various statements and gone through in detail on what was in and what was out. And I know we might have to do that over again, and then there are jail calls that y'all had not reached yet, but I think the state had represented, there were 5 or 6 of them, and y'all know which ones they are. So that y'all all know, right?
So we know about the jail calls,
Okay.
that assuming that the state's not expanding that list.
They're not going to be expanding that list, are you?
And
Not the jail calls of Mr. Copeland, no.
Okay.
And when they say noticed of things that are in statement or past statements, I am aware that I'm not aware of any co-conspirator statements by Mr. Copeland I'm aware of the Garlington to Copeland
Right.
statement,
Yeah.
but
From Mr. Copeland himself.
I don't, when they say they've noticed us on statements by Copeland that are in his statement, in his prior statements, I don't know what that
All right.
means specifically.
Okay. So are y'all including within that, like, here's what Garlington told me?
Yes.
Okay. So, all right. So that y'all do have, and how many of those are there?
How many statements of Garlington to?
How many co-conspirator statements from any alleged co-conspirator are there that y'all are going to be introducing through Mr. Copeland? Or potentially introducing through Mr. Copeland?
At least 3 co-conspirator statements, 2 from Garlington that is contained within the June 10th interview. And then there's a jail call with Mr. Copeland and other unindicted co-conspirators as well.
Okay. So defense,
If there's more, we can correct that tomorrow, but.
Okay.
I'm thinking of-
all right, so take a look at it tonight and make sure. Okay. And then with regard to the other acts, do you want me to I think it would be a good idea to have a deadline for giving the exhaustive list over. So do y'all want to make a suggestion as to how long y'all need to do that?
Just 1 second, Your Honor. Monday, Your Honor, is that?
That's great. Yes, that'll work. So that'll be Monday, August 5th.
For the intrinsic act.
Yes. Okay. Moving on to discovery reports of state's experts. Did you know specifically which reports or which experts you feel like you're missing reports from? Okay.
Your Honor, I just asked my coworker that I'm privileged to work with to email to your honorable court's coworker and everyone else the November 17, 2023 written order on this topic. And I don't know if this court has seen it, because and if you want the court reporter to be emailed out, I didn't do that either. Apologize. But we had a hearing on this on or about August 21, 2023. Opening statements were approximately November 27, 2023. And we have no reports of any gang expert. We got a PowerPoint the day of testimony from the first witness is my memory, but if I'm wrong, I apologize and please correct me. And that PowerPoint had to be gone through and had to be excised. His name is Detective Belknap, which is Belknap. Then Detective Dennis testified. He was allowed over strenuous objection to say that we did this work and we spoke with witnesses and we spoke with victims and we spoke with co-conspirators and we spoke with people who identify themselves as a gang member in IF or a gang member in YSL. And based upon that, we know that the following crimes occurred and here's some 911 calls. I don't know who these people are. We have no background. That's in my opinion, that's a confrontation clause violation because it's the police officer doing the work. We never got any reports. When I've asked for the reports, I was told that that's under lock and key by the City of Atlanta Police Department. And he, meaning Detective Dennis, no longer works there and cannot get, they have a gang book. He described it as a gang book, but they can't get it. Detective Belknap said he cannot get access to give out that gang book. So we're basically in the dark and we're hitting as best we can, but this is all over objection. I have no idea how to challenge. Like you heard earlier today, there's a lot of information for the court, but you heard earlier today that, God forbid, it's at 7:22 p.m. The 911 call goes out and Mr. Donovan Thomas is shot. He's killed. It's on video. It's bad. It's a drive-by shooting. He gets shot. Multiple gunfire. 2 other people shot as well, but thankfully not fatally. Within the next several hours, so it's 7:22, so within 5 hours, Mr. Copeland says that abodes that are close to his family members, and you heard a representation that Mr. Williams, they said stepfather's home was shot. I have no idea who shot that stepfather's home. I have no idea who to speak with about it. There's a 911 call about it. I'm not conceding that it was done by a gang member. That's why it's impossible to cross-examine. The next witness, who is deemed an expert by Judge Glanville, is a detective Gaither, which is Gaither. And she testified as well. I didn't make a report, but she goes into, I spoke with people, they're unnamed people. It's the same thing. I would like to know who these people are because I'd like to talk with them. Because if they say, no, I never said that, that's important for the jury to make credibility determinations. That has all been kept away from us. Judge Glanville ordered the state, and it's just, it's easy to read the order, but I wrote the order after the argument, but he signed it. In order to permit a meaningful opportunity to cross-examine, all expert notes, reports, documents, statements, basis of opinion are required to be disclosed by each expert for the prosecution as to the underlying facts or data so cross-examination can properly, lawfully, and constitutionally occur. That's right out of the case of Harris, Harris versus State, which is 314 Georgia 238. It's in Division 6A, is in Elisa 875 Southeast 2D 659 2022 case, where our Supreme Court said that is not the rule in Georgia, but we encourage trial judges who can control the proceedings to order that to be done, and Judge Glanville ordered it. The state never gave us those witnesses. Then you have Detective Belknap talking about, well, at APD, meaning Atlanta Police Department, we have six criteria that we designate someone a criminal street gang member and a criminal street gang. Then you have Detective Dennis. He gave those same policy requirements. Then you have Detective Gaither. She gave the same ones. It is my understanding that the next two, which is Detective Underwood, which is UNDERWOOD, and she's going to testify, I assume. I don't know because I have no reports. Similar policy. And then you have Investigator Viverito, which is VIVERITO, also with the City of Atlanta Gang Division of their policy. All of this is cumulative. All of this, I have zero, none of us has any type of documentation. And the way I understand the rules, an expert, yes, they can rely on hearsay. They can rely on the opinions of others. I understand that. But when asked and when you testify, you can challenge those opinions and those statements. So you have to know who said them to you, and all that has been kept from us. So that is, I filed a subsequent motion that it's cumulative, that how many experts you need. Judge Glanville said, it may be getting cumulative, but he did not rule that way. But he said this could be getting cumulative, but he allowed the next expert to testify, which was Detective Gaither. And then I don't know how we have no reports when there's a written order. We have zero on it. It's hard when the expert is just saying, or the witness is just saying, well, I do this. I'm on the street. I know these people. Brian Steele, you don't know how streets work. And I go out and this is how I get information. People will talk to me because they know that I won't put it in a report. Well, that makes it pretty hard to say, well, I don't think the jurors should just rely on your word. I'd like to know who that witness was. Well, I'm not able to tell you. I don't want to tell you. I can't tell you because I left the office. That's the issue I'd like you to address.
Okay, well, I mean, I understand the frustration. If there is no report, there is no report. But what was the date of the order that Judge Glanville issued that you referenced?
It is, and it was emailed to your honorable court's coworker
thank you.
at 11, which is November 17, 2023.
Okay, 24,
No.
23, 22,
23.
23. Okay.
Thank you.
All right. And that's, unless I specifically change what's been directed in an order, all of the orders that have been issued continue to apply. So I'll expect the state to abide by the requirements of that order. And we'll have to address whether the other experts might be cumulative. Besides these gang experts, are there other experts who you believe there should be reports for that you don't have?
My knowledge, unless my mind is not working, I believe I have reports on everyone else.
Okay.
That's-
Anybody else?
That's my, if I misspoke, but that's my understanding.
For any of the other defendants, anybody believe there are other outstanding expert reports that you don't have? Hearing silence, I assume it's just those. Okay.
Your Honor,
Yes,
may I briefly address the court related to this matter?
you may. And one thing before you start, I want to ask, and I could be entirely wrong, but with regard to the experts that are being recalled, I would assume y'all are trying to present your case kind of in some semblance of order. So it may be that right now they're testifying as to ABC count and later they'll testify to XYZ count.
Correct, Your Honor.
Okay.
If there's some witnesses who were fact witnesses, so to speak,
Okay.
for a specific part of the investigation, and then they also will testify down the road about another.
Okay. All right. Is that all? Yeah, go ahead. And if there was something else you wanted to say, yes.
Your Honor, just briefly, I wanted to kind of orient that as different gang experts that the state have called to the stand, this argument has been addressed or raised to Judge Glanville. And part of it is gang experts, unlike GBI experts on blood or touch DNA, the police reports that the state has related to the underlying crimes. This is obviously a crimes that span a decade. So the gang detectives, specifically Detective Gaither, Detective Dennis, they worked, I think, approximately 26 retaliatory shootings after the January 10th murder of Donna Thomas. So they worked as the lead detectives. For example, we have put evidence, you've heard about D'Angelo White. That was a shooting, attempted murder that happened that Detective Gaither and Dennis picked up after essentially an aggravated assault detective with an APD had it, because they're gang detectives. So when they talk about, they don't have, as you would have in, say, a scientific report like a 50-page treatise of the Young Slime Life Street Gang. They have worked these crimes, and their reports or warrants that the state has have been turned over. And so the basis that they state their opinions to the, they speak from working the case, from talking to people. So
they're
that's
experts based on their experience.
yes, Your Honor. And part of the issue arises is the reports that the defense is requesting, they do not have. And so, for example, I believe it was Detective Gaither and or Dennis, they mentioned, they are retired from APD. So when you ask them, well, do you have some other additional reports? They say all the reports I made, were in my file. So the state is not aware of any reports from these gang experts that we have that has not been turned over. The state believes that those kind of four corners from this decade of acts in the case don't exist, of like Detective Gaither or Dennis didn't write some large report in total.
Okay. Has the state asked, not the individual detectives who have since retired, but APD? Do we have all of the reports relevant to this case?
Yes, Your Honor, and I will defer to my co-counsel because I came on this case in December, but my understanding is that that has been Chief Deputy Love or Hilton, correct me if I'm wrong, to the court.
Yes, Your Honor, the reports, this is an issue that has been addressed multiple times after the order was entered. Every time that we address either Gaither, Dennis, or Belknap, the issue is raised that there is an absence of a report. Judge Glanville, the court can search the transcript for this. Judge Glanville has addressed repeatedly Mr. Steele's motions and his assertions regarding their lack of a report from various experts. I'd ask that the court review that portion. You do a search for the word expert or report.
I'm not going to do that. Sorry. I mean,
No, I don't have any problem with that, Your Honor. My point only is that we've addressed
got
that.
enough to read besides
We've
searching
addressed
for
that issue
expert.
multiple times.
Okay.
And Judge Glanville has ruled on Defendant Williams' repeated motions for a report of detectives Gaither, Dennis, Belknap, our gang experts. Judge Glanville has ruled on that even after the order that was entered. So I don't believe at this point that there is any further ruling unless the court wishes to reconsider the rulings that Judge Glanville has previously made. I don't believe that there's any further matters to be ruled on as they relate to expert reports and the gang experts that the state has identified for the defense.
All right, just make sure that you have abided by and continue to abide by the order issued on November 17th, granting the motion for complete witness list and expert reports and analysis and findings, okay?
Your Honor, may I respond to that briefly?
Yes.
And I was going to provide one case to the court.
So,
Either before or after.
okay, all right,
Mr.
yeah,
Sharp.
no, we'll let Mr. Atkins
Thank you.
finish. Let me, and Mr. Steele quoted it for us, but what the order says is all expert reports, their analysis, findings, and the basis for same must be provided to counsel for each person accused instanter, which means immediately. So the way I read that, that means even though this goes beyond what our discovery statutes might require, this order is what controls. And so even if there is not a written report, you need to give to the defense any findings that these experts have made and the basis for those findings. Okay, just make sure y'all understand that.
Yes,
All
Your
right.
Honor.
Okay, go ahead.
The case, and I apologize, but it's Hassan v. State, which is a March 19th, 2024 Supreme Court of Georgia, Hassan v. State. The version I pulled up is from when it was just pronounced, so it has
What's the
site.
S24 number?
It is, Your Honor. So I need to pull up another version. I have the version I saved when
Okay.
it first got published. So I have a 2024 Georgia Lexus 7.4.
Well, that'll work. 2024 Georgia Lexus
7.4, and then it gives a Westlaw.
7.4.
Yes, Your Honor.
All right, I don't use Whistle.
But what I
I
wanted to,
used to. I just don't anymore.
I've only used primarily Lexus, Your Honor.
All right.
What has came up
Mhm.
briefly in defense counsel argument, but gets brought up is this case is important because it discusses when, for example, gang detectives are speaking about. Typically, experts can talk about or rely on hearsay
Right.
to make their expert opinion. So when you have gang investigators who have spoken, talked with a number of people, part of their response or expert opinion on XYZ is based on years of experience. And so this case has an important holding in relation to specifically, neither witness expressly repeated the out-of-court statements of any other person, although the detective testified that he was familiar with the Ramsey investigation, which was some other investigation he was talking about, and referred to speaking with another detective who worked on it. He did not specifically state what the other detective told him or how he developed his familiarity. So it was not obvious that the evidence was hearsay, such that the trial court should have sua sponte excluded it. And this was a gang case where, kind of like how Detective Gaither, Dennis, and then Detective Viverito down the road, they reached their conclusions. And so if they are not directly deriving what their statement is from hearsay, as an expert, this case is helpful to illustrate in the context of a gang expert, how that can come up. So I just wanted to share that, Your Honor.
Appreciate it.
Thank you.
All right.
Thank you, Mr. Sharp.
Okay.
So, Your Honor,
Yes.
I don't want to be taken as crying over spilled milk, but I'm really just trying to bring things to your attention. Miss Love referenced in kind of, I feel like I was the one that was making the most noise about the reports, especially investigators' reports. And the reason I was doing that, and we're not talking about expert testimony right now, reports by an expert. These experts were also testifying as fact witnesses.
Right.
And there were several times, it was Investigator Gaither, and I believe it was Investigator Dennis. I could be wrong on that, but it was definitely Investigator Gaither and another investigator. I think it was Dennis. And they testified to doing things in these cases.
Mhm.
And we're looking at a lack of reports indicating that these tasks were done, showing photo lineups to certain people, interviewing witnesses. And I complained about that. And I said, well, where are the reports? Because at first I was, in cross-examination, well, wouldn't that have been something you would write a report about? And they said, well, we did write the reports. And so we met out in that side room with Investigator Gaither. But I believe Investigator Dennis, we also talked to him, and they insisted that they wrote reports about this work. And it is correct when they said, when we left, we're retired, we cannot access the reports,
Sure.
but we left them with APD.
Okay.
The state has stated that they don't have these reports.
All right, that should not be happening. We'll take that back up when she comes back in here, whoever she is.
The state has stated repeatedly that they don't have the reports, and I think all of us are left in this quandary where the state's saying they don't have reports, but the witnesses are saying we wrote reports. And
Okay, do you have dates for any of that? Or have you previously discussed with counsel for the state
well, when I brought this up to,
what you think is missing?
yes, well, unfortunately, those witnesses have already testified. So of course I would like the reports, but going forward, and the part of my frustration is when the state says we don't have reports, and the witnesses are swearing there's reports,
Right.
so we can't really nail the witnesses on it, and the state's saying, well, we can't hand anything over either. Then we talk about it, and the court at the time just kind of said, well, there was a hack in 2018. And
That's actually what I was literally about to say, is it's possible that for some of these things, I mean, we all remember, we were all around in 2018, the city of Atlanta there was some huge cyber attack, and lots of things got disappeared from everywhere, wiped out. So if that is the excuse for some of it, it's probably legit.
well, I'm
And
not
it's
saying
gonna
it is
depend on
or
the
isn't
dates.
legit. I'm not saying it is or isn't
Right.
legit, but
I'm happy to bore down on it some more and talk
Because-
specifics.
I mean, it wasn't even, I can't recall if that was even suggested by the state, but that was just thrown out there. Well, reports are missing because of the hack. And I'm like,
Well,
well, how do
I'm
we know that?
happy, yeah. If you want to get together a list, and I mean, maybe more so for the witnesses going forward, and these, we're at this point not really talking about expert reports, we're talking about police reports, fact basis that ought to be out there. And if you want to in detail get that, because that is frustrating for everybody. I mean, yeah, it's out there. You wrote it down. So unless it disappeared in the cyber attack, it ought to still be able to be gotten, even if not by that witness, because that witness is retired, by the state, because the police and law enforcement are a part of the state. And so it is within the control, if not the custody of the state. So I'm happy for us to bear down and bore down and drill down some more on that. If y'all want to give me specifics, or if you want to, well, give both to me and share with the state specifics, because that will help them as well, to not just say, hey, APD, please give me everything about this case. But there should be a report from Detective Gaither dated August 2nd, 2000, about a lineup she did. And then they can actually search for something. So let's, to the extent y'all want that, and you're certainly entitled to it, let's get details together so that we can give that to the state, so they can give that to APD, and we can actually hopefully find something if there is something out there but missing.
Yes, Sean. Thank
Okay.
you.
All right. Yes.
We
Yes.
turned over to defense. Every report from 2015, every report that the experts have referred to or will testify about, and the complete case files that exist for each of those reports.
Okay.
So we've turned that over. If I will await defense giving to us what they now posit they don't have,
Okay.
that we have not already addressed.
Okay.
And Your Honor, I am asking the court to refer to Hassan versus the state, 318 Georgia 673. It's a 2024 case that that's the full citation of the case that
Okay.
Mr. Atkins just.
Oh, perfect. Thank you.
Your Honor, I mean, with all due respect to everyone here, that's a bit disingenuous
I think
because
is your mic on?
I'm turning it on.
Maybe we need to take a look at that and see if it's still working.
With respect to everyone here, that's a bit disingenuous to say, well, we're raising this for the first time. We had the issue in court with Investigator Gaither. The state is very aware of what those reports are. I'm not saying I know all the answers here. All I'm saying on those previous occasions, there wasn't, in my estimation, from my vantage point, there wasn't a lot of effort, and it was just blame the hack.
Okay,
And-
well, thank you.
Yeah.
And I don't want to keep going back and forth with blame or bashing. I want us to be productive and talk detail so that we can make things happen. So thank you. All right, what else? If anything, that we can deal with today? It's okay to say that's about it for today because I've got some homework anyway. All right, so we will adjourn for the day and we will see everybody's smiling faces at 8:45 tomorrow morning. Thank you all.
Your Honor, before the court.
Oh, yeah, there's one more thing for me too. Go ahead.
There is a scheduling matter that we would like to address with the court.
Okay,
With a member of the bench at the bench.
okay, come on up. And I guess one person from each team. Earbuds and what have you over here that I have never used before. And if we're going to be using those during the trial, I would like a little bit of practice on them before we get in front of the jury. So maybe, the next day we end at 4:30. Y'all remind me and let's all figure out how those work because I don't know yet. All right. Are you just going to be representative of everyone?
Yes.
Sounds good.
Welcome to Fly High Productions with Mr. Follow Up. Hey, so check this out. Now, Judge Crossman came in there like she gonna move this process right along, right? Today has been one of Today just been drawn out. The more she tell them not to repeat something, she rehashes it herself. Man, let's get on with it. Bring the jurors back in. We need to see some witnesses. Let me make my judge on this case. What y'all playing right now? I'm talking about they sideboards ain't no joke.
The
Here we
state,
go.
due to
Come
a
on,
scheduling
Simone.
matter,
Miss Hilton.
may want to, whenever we do pick back up with the jury, which hopefully will be soon, but I'm not sure yet what all we're going to get finished with this week. If we bring the jury back next week, there is a request for the court to consider having a witness who is not Mr. Copeland be the next witness because of a scheduling matter for the attorney who was examining Mr. Copeland. Now, we have to redo at least part of Mr. Copeland's testimony anyway. I don't know if that's an issue to y'all. We're going to have to come up with whatever we're going to say with regard to, you may be hearing a lot of this again, and you're going to need to disregard what you heard before. We'll have to work on that, and y'all be thinking about that. That's y'all's homework. But is there objection to moving to another witness and coming back to Mr. Copeland? And if so, what is it? And then I'll consider whether I'm going to permit it or not.
There's an objection to going back and telling the jury anything about disregarding Mr. Copeland and having to do it all over again. It's impossible. There's no way in the world.
All right. Well,
The jury
yeah.
just disregard Mr. Copeland.
Okay, but that's not what I was asking. I understand that you just think that is a total disaster and makes this trial one that needs to be a mistrial. I understand. But that aside, just with regard to scheduling, assuming we are going to go forward for the purposes of this discussion, and assuming that, I mean, y'all don't stipulate to everything he's already said and that we have to redo a part of his testimony. Well, whether we do or not, we're going to have to continue his testimony. So is there an objection to essentially taking some other witness out of order in the midst of his testimony?
Your Honor.
Yes.
Keith Adams on behalf of Mr. Williams. Mr. Steele and I have consulted about that. And I don't purport to speak for anyone else. We do object to that. We believe that given the complexity of Mr. Copeland's testimony and the issues surrounding his testimony and the confusion that will probably already attach to a jury coming in and seeing some of what Mr. Copeland's heard and testified to and possibly having to be instructed about disregarding some of his testimony, we would object to going to another witness.
All right, I appreciate it. And I think with that objection, you know, it's well-founded. So y'all do what you have to do with regard to who might be handling the examination, but we will pick back up with Mr. Copeland and finish with him before we move to another witness.
Would you allow another member from the state to continue his examination?
Considering that we're going to have to, well, as I understand it, there are a couple of days of, and I don't know whether y'all got testimony out of him or not, or if it was just a discussion of whether he was going to plead the fifth or all of that. If there was there testimony from Mr. Copeland prior to the motion to recuse on the 12th?
Yes, sir.
Okay. All right, considering that Ms. Hilton handled that testimony, and we don't normally switch attorneys mid-witness, there is now a request on the floor to do just that, to switch attorneys mid-witness. We're switching judges anyway, and we're redoing some things, so it's a little out of the ordinary anyway, but if there are objections to that, I will entertain those.
May I speak?
Yes.
I would hope that that's not an issue. As of tomorrow, we rule on qualification, so that Ms. Hilton can go wherever she would like to go. As far as I'm concerned, we will not call her for several months. Who is the witness that would be substitute? I heard what Ms.
I don't know. Do y'all have another witness in mind?
What is the hiatus? Is it a week?
I don't know that either.
Will be 1 week, Your Honor, would be my absence, would be 1 week. Your Honor, we do have several witnesses. It would be the state's intent to potentially just go in order of who we have kind of listed. So you wouldn't be calling anyone from the bottom of our witness list, but it would be someone within the same act that we're.
So you just essentially skip over him and go to the next witness on your list and then come back to him.
Yes.
But I've kind of already entertained an objection to that and said, no, you can't do that. So the question on the floor at this point then is if we're continuing with Mr. Copeland and not picking up with another witness in the middle, is there an objection to another prosecutor handling the remainder of his testimony and whatever needs to get redone? Get redone.
I object.
Sure.
I mean, the state just trying everything today, ain't they?
Sure.
I mean, the state just trying everything today, ain't they? Just trying everything today, ain't they?
Speaking only for Mr. Kendrick. Mr. Kendrick objects.
Okay. And on what basis? Because you want to make it difficult for the state.
No,
Which is fair.
Well, no, Your Honor. This whole thing is messed up.
All right.
We've got to redo this witness.
All right.
We can't redo the witness.
Okay.
I don't even want to get started. So switching out the questioning attorney
All right.
is just even more complicated.
Okay. So let me take that part of this under consideration. All right. Okay. So the other thing that I had
Your Honor.
is I
Your Honor.
asked.
Judge,
Yes.
I'm sorry.
yes.
I'm sorry. Didn't speak
Oh, I'm
quick-
sorry.
No, that's
Did you-
okay. I didn't speak quickly enough, or my microphone didn't come on quickly enough.
We'll blame
Um,
it on that.
Yeah, it's the microphone. Just to be clear, on behalf of Mr. Williams, we don't have an objection.
Okay.
And I don't believe, I'll let everyone else speak for themselves, but I don't believe there are any other objections back here.
Other than the one already voiced by Mr. Harvey.
All right, so that's just us.
Okay.
I object to Mr. Adams making me look bad.
Okay, well, so noted. All right. Well, I'll think about that one. Okay, so there had been Miss Love put on the record this morning that she had made the request for the Monday morning meeting. That was the June 10th meeting with Judge Glanville and Miss Bumpus and others at some point in the afternoon of the Friday the 7th. And I said I would get that ex parte because it did get taken down. And so I reached out to the court reporter who handled that, and she has given me a rough. Now this, and I'm going to share it with each of you. It's a rough, so this is not the official transcript, but I mean, she's an experienced court reporter, and this is probably pretty close to what it's going to be officially. But anyway, I'll just share that with each of y'all so that everybody's on the same page about everything. Okay. So if y'all all want to come up here and get a copy from Ms. Persfield, after that, we will be in recess for the day. Thank you.